and I think that it is time to start our 31st Global Digital Encounter. Dear participants, dear friends, well, TRIPS will be 30 years. Global Digital Encounters are at number 31. So we are super happy and honored to serve our community all over the world in providing a non-conventional form of reflection on all possible topics of intellectual property. And for this 31st Digital Encounter, we want to test the borders of IP rights. And in particular, we want to discuss about compulsory licensing and beyond. What if all of a sudden the IP mechanism for protection and promotion of innovation need to be alleviated? We noticed when the COVID crisis started that perhaps there were needs for major adjustments in some of the rules to access, produce, distribute medicines, or perhaps not. But we noticed that there was a big question mark on this question, on this issue, all over the world. The COVID crisis revived the national interest, including the EU interest, and the international debates on flexibilities related to patent rights for public interest, including for health issues. From waivers to patents, to compulsory licensing, to modernized rules of compulsory licensing all over the world, to enhance national legislation and EU legislation in this respect, many countries, many stakeholders are reflecting, are trying to initiate legislation, have taken action already. The issue is, of course, patent law, but is also issues connected to data, to transfer of know-how, to confidentiality in the process of innovation. So this is a very, very broad aspect. And for these issues, we have invited the most, or among the most authoritative persons in the world in this respect. We have speakers who have immense experience, have very different views on which flexibility should be developed, if flexibility should be developed, how they should be developed, who they serve, and who they may not serve. And our speakers will be moderated by Wolf Meyer-Evert from the World Trade Organization, who in his neutral position will, of course, animate the debate. So it is our honor, our pleasure to really reflect on this. We reflect on this important topic today. This is the mandate of the Global Digital Encounter. We remind you that we have posted readings for those who want to know more, that we will reply to the questions in the chat that will be raised, and also we will issue a report and small quotations of the debate today. We are absolutely committed to continue this discussion that we had launched actually already in May 2020, and that is a constant line of study of the Global Digital Encounter. We are next to all of those who want to discuss, think, test borders of intellectual property for the good of the IP system, for an IP system that serves mankind to its best. Thank you for your attention and have a good Global Digital Encounter. This will be the last one of the year. So we are just starting the encounter. This is also an occasion for me to present my best wishes to all of you, to confirm that next year we will have other fascinating Global Digital Encounters, and to remind our community from all over the world that we are next to all of you for the forthcoming years. So enjoy this Global Digital Encounter under the moderation of Wolf Meyer-Evert, and I leave the floor right away to our coordinator, for his welcome words as well.
Thank you. Thank you, Laurent.
And also, I just forgot, and it's very important I remind it, this is a pro bono activity. and many people help us all over the world, sponsored information, pro bono as well, and we are particularly grateful to all our community.
Thank you.
Javier.
Thank you, Laurent. Very briefly, as usual, very happy to have you here once again in our 31st encounter. This is a question of high interest, and I would say that sometimes of high tension. I always explain to my students that there is an IP deal. I mean, the power the government grants you, all right, but there must be some limitations. So what is the IP deal here? We have a very good panel of speakers and a moderator that will explain to you and will discuss on these topics. So I'm giving the floor just right now. Thank you for being here. Remember that you belong to this community, and the floor is yours, Wolf. Thank you.
Thank you very much. Good afternoon from Geneva. Thank you to the organizers of the Global Digital Encounters for inviting us. Let me just briefly say that I'm speaking in my personal capacity, and so nothing I say should be associated with the WTO Secretariat or its members. But let me dive right in. The title of this Global Digital Encounter is Testing Borders of IP, Compulsory Licensing and Beyond. And although compulsory licensing is, of course, the focus of attention in the recent discussion, let me just briefly step back one moment and think about the different borders of IP rights. Javier has just mentioned the deal, the balance in the IP systems that tries to balance different interests. And of course, the borders that are designed in the IP rights are of different natures. There are, of course, the scope of IP rights that determine eligible subject matter and associated rights, which is already a border vis-à-vis those elements that lie outside scopes of protection. There are the general limitations and exceptions, of course, covering classes of activities or immunities and licenses of right. And then there are instruments that address more specific, more case-by-case situations, such as compulsory licenses or government use orders that are all recognized in the international system and, of course, also in the TRIPS agreement. So you can see that, you know, if one characterizes these different borders, one could think of some of them as more general policy considerations that are inbuilt into the system, that design the balance in the system, and some are used or designed to address more ad hoc situations where individual constellations where the public interests may be deemed to justify overriding an IP right. And there, of course, compulsory licensing is one that comes to mind. Now, I want to posit briefly that, or maybe just share an anecdote. When the TRIPS agreement was amended, and its amendment came into force in 2017 to add an additional flexibility, compulsory licenses for exporting to countries that have insufficient manufacturing capacity. One of the countries that ratified this amendment first was Canada, and the intervention of Canada at the time when it was adopted was that they said they did not expect this tool, this new compulsory licensing for export tool, to be used very often. Because they considered that it was not necessarily, its function lay not purely in actually addressing an individual situation, but to be a more general strategic availability that would help those countries to negotiate with right holders rather than actually having to employ the compulsory license. So I would invite the speakers to consider where the role of the compulsory licensing tool in the IP system lies, or maybe it has multiple roles, and to consider in that context, how we think of borders of the IP rights. In recent days, the introducing organizers have already mentioned it. In recent months and years of the pandemic, the IP system has again come into focus, and its borders and tools to react to specific situations were at the center of that. We have the European Union's proposal for EU compulsory licenses. We have the TRIPS decision at the WTO that was adopted at MC12. We have ongoing negotiations at the WHO for a pandemic instrument. I would invite maybe in our discussions our speakers as a first round to share their views on how they place these initiatives in the light of the range of borders of IP rights that I've just tried to characterize. So, what are the objectives of these initiatives? The TRIPS decision, the EU compulsory licensing proposal, and the INB negotiations at the WTO against that background of different borders of IP rights. Maybe I'll start with you, Bruno, if you like.
Yes, thank you. Thank you, Wolf, for first of all, for inviting me, for giving me the opportunity to speak. My experience and exposure to compulsory licensing took place last year when I was asked, together with SAPI University, to write a study for the European Commission about compulsory licensing. That study and the initiative was triggered, of course, by the pandemic. That through a very, I would say, strong attention to the need for legal instruments to make, in this case, it was drugs available, but it was going beyond that because we are living in a time when we go from one crisis to another. When it's a pandemic, it can be natural disasters, it can be other crises. We have war ongoing, and there is, I would say, a strong and growing awareness with governments that intellectual property is not only and no longer, and I feel that very strongly, no longer a tool of competitiveness only, to make sure that competitors can secure market share or gain market share and eliminate each other, but intellectual property has now become a tool for societal development, and in cases of disasters, a tool for maintaining societal development at a minimum level, to make sure that certain goods are available to meet catastrophes. And it is in that respect that the study was made, and not surprisingly, found out that the current national systems in Europe do not work, have hardly ever been put into effect. And where they have been, it was mostly done in countries where there was a court system that could deal with compulsory licensing, and almost never, except one famous case in Hungary, where the authorities imposed compulsory licensing. And that is one, I would say, ascertainment, one constatation that the system doesn't work. The other reason why it doesn't work is that it is national. It is purely national based, and there is, because of the inefficacy of the territoriality principle, that compulsory licenses are governed by national law. And in modern manufacturing and modern, I would say, in every good, there is always import and export needed. Multinational companies, and every sophisticated product has more than one manufacturing place. Assembly takes place in a different country than the manufacturer. The resources, the sourcing of components is coming sometimes from outside Europe. So this makes it all very, very complex. And the compulsory licensing legislation was based on an very old principle, assuming that you had one patent, one product manufactured and consumed in a single country. So where the demand and the production took place in a single country. That is completely outdated, and those problems were exposed in the study. And then the Commission came up with a much more radical proposal that the study certainly did not suggest, as it is now on the table, with a community level of compulsory licensing, only for times of crisis, but there we are. And again, I repeat, I don't think we can go around the finding that intellectual property as we knew it, just as a tool for competitiveness, that role is over, or not over, but is no longer predominant. We will need to think about the role of intellectual property to attack our societal challenges. And we need, in that respect, governments need a last resort option. And that's also the whole purpose of the study, is to stress that compulsory licensing is the last resort option, and that other measures are needed to encourage parties to engage in voluntary licensing. And that is certainly also the message of the study that was made. And I think in the whole communication of the Commission, that is also the principal message that you read behind or between the lines when these proposals are being made.
Thank you, Bruno. I'm tempted to ask more questions, but let me first give Tilman a shot at this first round, where we are sort of in the general characterization of recent initiatives. Tilman, please.
Thank you very much, Wolf. I felt the same. Bruno, you already sparked some ideas. But let's do it step by step. So where am I coming from? And thank you very much for the invitation, by the way. It's my first time in this community, and it's an honor and a privilege. So where am I coming from? My day job is I'm a patent litigator and licensing lawyer, external counsel in a law firm from Germany. But today I'm trying to put a different hat on, which is my university professor hat. I'm also teaching at the Technical University of Munich. And that means that by nature, so to say, I have to approach these things neutrally and objectively, so to say, and maybe from both sides, legal side as well as, so to say, the societal need side. And maybe to put one point first, Bruno, you said patents, for example, IP rights were there to, allow for healthy competition, return investment on research and development. So that the typical reason, so to say, for the patent system. I'm not disagreeing. I'm just thinking that there's a broader aspect to that. And TRIPS actually has shown that on the example of compulsory licensing very much. It's written there, so to say, in the black letter law, that there must be a balance between enabling innovation, so return on investment, but also access to critical technologies in crisis times, so to say. So that's already in TRIPS. And also more broadly speaking, when we look at and I take the example of a patent, when we look at the backbone of the patent system, the idea is to further innovation by granting time-wise and otherwise limited monopoly rights to enrich the prior art and therefore allow the public to jump on these inventions and use them once the patent has expired. So there is already inherently in the black letter law and in the whole concept of the patent system, I would say a balanced view. And I could give you many examples, equivalent patent infringement where legal certainty and accessibility and return on investment and all these things are evened out, so to say, by case law, balanced against each other. And that brings me to my main point. I'm always a bit skeptical when there is regulatory intervention. That starts with who is actually drafting the rules and continues with who is then actually implementing the rules. So to your point, Bruno, should it be courts? Should it be, authorities of whatever kind? And that's maybe a point for the detailed discussion. We have seen in the last years, especially this year, so to say, all in spring, quite some hectic initiatives, especially by the European Commission. One that is maybe not so much known to this audience here is the draft Standard Essential Patents Regulation, which also, so to say, aims at limiting, so to say, patent rights in certain ways. And there again, like here, there are two camps or maybe even three camps. It's very controversial. It's a heated debate. And the basic question, I believe, is, are we in a situation where regulatory intervention is needed with all the problems that goes with it. Poor drafting, poor implementation, on which level, national or EU, maybe international, as we have Wolf here. So lots of things to think about. What I would think is, I mean, and maybe now quickly, specifically on compulsory licensing, do we actually have a problem? I'm a German litigator. There is less than 5 cases where compulsory license was tried to be granted by the court. In our system, it's the German Federal Patent Court, so the revocation court for patents that deals with that in interim expedited proceedings. There would also be main proceedings, but decisive are the interim proceedings, because when you want to argue urgently, so to say, need access to something, that's the procedure to go. And on top of it, the appellate instance is the German Federal Court of Justice, so our highest court in civil matters. Only one case, Ralte Gravier, where a compulsory license was granted. Only maybe 5, let it be 10, I don't know exactly, cases were filed. You don't find case law. You don't find many articles. I'm doing quite a bit of life sciences work, and I'm not having these cases. So the question is, are we kind of fighting with an elephant, a mouse, in terms of practical problems? Last point on that, and then I would finish up for this round. COVID. I mean, of course, I mean, that triggered many thoughts and sorrows and all that. What was the problem? It wasn't access to patents. The problem was capacity and capability to make the drugs, the vaccines, and get them out there. And that's why I think, as a first big point, this draft compulsory license proposal fails to consider know-how, trade secrets, these commercial aspects, and only deals with IP. So if you will, you go half the way, but if you would do it in a serious way, you would need to go all the way.
Okay, thank you. Thank you, Tilman. We're right in the middle of it, I can tell. So I think I'll just go around back one more time, because I think one of the points we have here is, is the tool working or is it not working, and how do we know? I think, Bruno, you said your study showed that it is not working, and maybe you can just briefly comment on this, in light of my initial anecdote of the Canadians who said the purpose is not having a lot of cases, the purpose is having the threat of a possible tool, and that will be the impact. That's of course a very different way of looking at it than the crisis mode that we had in recent years, where people looked to flexibilities and compulsory licensing to have an immediate effect. And I think in that context, whether the IP compulsory licenses were the right tools to have a short-term, access impact, there I think the views are also very different, as Tilman was just saying, whether the IP rules by themselves or compulsory licensing by themselves can achieve that. So just a very quick point also on how you concluded in your study that they are not working. Could the absence of many cases not also just make the Canadian point of saying there are a few cases to prove the concept, but the impact is not in having many cases? What do you think about that?
Well, the fact that there are not many cases, of course, you could reverse the question, because it is not working. There are so few cases. And during our interviews with stakeholders, we felt very much that most of the stakeholders and most IP owners were not concerned by the system of compulsory licensing, because they know it doesn't work. So it will not be asked for. And that is something I think that the Commission legitimately wanted to tackle, to say if it doesn't work and the IP and the owners know it, we should do something about it, to have a larger stick to beat with, and we used very often the comparison of the stick and the carrot. You must use a stick sometimes to bring the parties together, and sometimes give them a carrot to make sure it really happens. And I agree with Tilman that the system originally has a good balance, and TRIPS also shows that balance. The problem is that we are now facing crises, more and more crises, and in times of crisis, and the literature shows that very much, what you need in times of crisis is access to the most recent technology. COVID is also an example. You do not need access to existing patents, existing technology. You need to start developing something very, very new. And then there is a societal need or an urgent need to have access to that very new technology for whom the patent applications are sometimes not even published, as was the case for the vaccines. And one of the things that the study also suggested is maybe in certain countries you can also have licenses for patent applications. Is that something that should be considered? So that is one of the suggestions that were made. But the problem is that indeed access to very, very recent technologies is not regulated by compulsory licenses. It's mostly for granted patents. Access to the know-how, to the data, is also a problem. Very interesting, what our study shows is that all stakeholders agreed that in the medical sector, in the health sector, it would not suffice to grant compulsory licenses. The data exclusivity issue is a larger issue than the patent issue, the IP issue. So their access to in the healthcare is mostly made more difficult because of the rules on data exclusivity than the rules on patents. And that message has been taken also at European level, I think.
Thank you very much. Tilman, very short reply on the working, not working, and how do we know?
I mean, the problem here is that you can always turn the facts, so to say, in a particular way, depending on how you look at them. You could say there aren't any cases because the system isn't working. You could also say there aren't any cases because there aren't any problems. Heaven knows, right? I can only work with, so to say, practical experience here, and I would like to make one broader point. The compulsory license regime, at least in the German national law, is not at all limited to the health sector. That's just where it mattered most in the past, but I could see critical infrastructure and all these things in war times, so to say, war economy. And unfortunately, we're not in the midst of it, but maybe at some point here in Europe. So I could see needs coming up. Question is then the national system not good enough? I think there is no doubt that German judges applying German national law would grant compulsory licenses where they really needed to master a crisis, be it a health crisis, be it some other crisis. Those are, by the way, also the cases where the proportionality defense against an injunction is being discussed. So that's a second tool which is available to be used by a court to say, no, there is a public interest. We don't grant an injunction. You can continue to be on the market and you might have to pay damages and what have you. So I stick to my point. Where is the need for regulatory intervention? What I think, where you absolutely have a point, Bruno, is, of course, it's very burdensome to run country by country by country to try to get a compulsory license. In all of these countries, you might then have diverging decisions by authorities, by courts. It's a mess. So why not have something on the EU level? I'm not against that, I must say. Quite to the contrary, I think that would be very efficient. Now, question is who should do it? I mean, that's the elephant in the room. And my clear conviction is this should be done by judges. They have patent law experience. They have, in some countries more, in some countries less commercial experience. We do have now a unified patent court dealing with patents, at least in Europe. So I could see that happening. We do have sort of judges at the EPO. So why not use it more broadly and let the EPO deal with it, although it's not an EU institution. So the harmonization angle of this, I think, makes a lot of sense. But then it comes to the details, and the details are what is being regulated, what will be the practical implementation, and here I fully share your view. I mean, not getting access to the data where data exclusivity protection exists in the health sector, you can forget the product, full stop. right? We then have SPCs, we have orphan drug specific rules, and so on and so forth. So this is a huge project if it were to be made in the right way. And what I've seen so far is just the tip of the iceberg and not good enough.
Thank you. I think we're getting closer to the second round of question, looking at a little bit more at the technicalities. And I wanted to pick up on one point that is coming. I think that is comes out in the discussion on, should it be courts or should it be governments that decide to issue a compulsory license. I mean, in principle, of course, compulsory licenses are often used as a sort of collective term for all of these uses without the authorization of the right holder. But I mean, in technical terms, they of course can be very different. The application of a competitor to use a patented process or make a patented product is one thing, but a government decision to override, as it is fashionable to say, override a patent and order the production of a particular product is a very different context. And I think even in Europe we have examples of where courts deferred to the political dimension of granting a compulsory license, and that there was no obligation to do so in the Spanish case. But isn't both necessary? Aren't both functions necessary in using this safety valve of provided in IP systems?
If I recall, I think there are also national systems where indeed an authority or government takes a decision on the license, and then a court, judiciary takes a decision on the pricing, for instance, or on the dédommagement, on the reimbursement, or the damages, or what have you. But like Tillman, I was a patent litigator. I was a diehard patent litigator until 5 years ago, and I have a very strong confidence in the judiciary, indeed. For a number of reasons. And what I see happening, and this is going on different levels, not only on the compulsory licensing, but also on the SPC, you see that proposals are on the way where actually the power of courts is being a little bit undermined, and certainly that of the UPC, as that who should be the best person to judge whether compulsory license should be granted, whether a SEP, an SEP should be enforced or not, whether an SPC is valid. These are patent questions that should be dealt with by patent judges. And what do you see happening? There are more and more legislative initiatives on the way that give that power to other authorities. And therefore, there is a risk that the criticism that the studies show that there is discrepancy amongst the case law, there is no uniformity, this will happen again by submitting those questions to panels of experts and organizations who have no competence in patents at all, and who are going to set up bodies of experts to decide on this. And all this through a community instrument, but actually, which in result will give rise to discrepancy and very varied contradictory decisions. That is a risk. That is a phenomenon I am a little bit concerned about, that the message of we want a uniform system is being contradicted by the implementation. And should we not have judges in place there to safeguard the interest of all the stakeholders concerned? That is a true concern that I share with Tillman. That is very, very necessary. Yeah.
Maybe just one comment before Tillman you come in. So in the context of the TRIPS discussions on the MC12 decision, one argument that or topic that was hotly discussed was how accessible the compulsory licenses that are clearly permitted under the TRIPS system, how accessible they are at the national level. And here, of course, a wide variety of implementation, particularly in developing countries, came to the fore, and it was deplored in some contexts that some of those implementations are truly very complicated and more than necessary. So the accessibility, the practical working of this tool be it to address an individual situation and have ad hoc short-term impact, or be it, just as a stick for a long-term strategic use, is of course important. And the system has to be shown to work to fulfill both these functions. So I think that different countries have taken very different approaches to this. If you look at the WIPO paper from 2011, but also others that you see, you have some countries where you have 4 or 5 different routes to a compulsory license, a minister, a court, individual government agencies, etc. And others are much more restrictive there. Yes, this may lead to discrepancy domestically in different countries, but to the extent that the decision is a policy decision motivated by the public interest of a particular country, would that not be the correct reflection of that?
I can follow your points, and I'm tempted to agree with each one of them. But maybe one comment, so to say, in favor of your point, and one comment which is again a practical comment to the contrary. So the one in the favor, if you cannot save the whole world, it's good enough to save half the world. That's better than nothing, right? So you can build your political sticks and you can do your regulatory interventions. And even if they aren't perfect, so to say, maybe it's good enough to change something in the market. Will that really change, so to say, the access to technologies in third world countries, where often patents aren't even filed for, except maybe for the pharmaceutical sector? That's the first question. So again, the question is, do we actually have a problem which needs regulatory intervention? The other point I would like to make is, I've been witness in lawmaking in Germany, and to some extent not involved, but I got information and had chats, etc., in lawmaking in Brussels. And I'm always scared when politicians touch areas where there is a high level of expertise and specialism. And of course, they do their surveys and they do their interviews and all these things. Still, my experience is that usually those proposals, and especially the ones which came out this April, SEPs, but also the SPC, etc., the BOLA exemption, the compulsory licensing proposal, all these proposals, if you read them as a lawyer, you find not a few concerns. You find many concerns and many problems. So they haven't been thought through. I think that's my point. So if you do it right. And question is then in which form? That's up to discussion. Harmonization, I think, is a key need. If you do something, you need to do it in a harmonized way. That means in Europe, ideally on EU level, if not broader. But you first need to do it right. And if it takes time, it takes time. And I have not the impression so far that those recent proposals which came out were thought through in sufficient detail.
Okay. Bruno, you want to come back on this, or otherwise I would move on to the sort of broader impact question that we had foreseen. So we've looked a little bit at the technicalities. So the next question is, of course, how well are they working? And in light of our discussion so far, this has to be looked at through different lenses. If you're looking at compulsory licensing as a strategic tool that tries to impact long-term behavior of right holders, it is much more difficult to assess, of course, whether it's working or not. We had this discussion just now. But in the short term, I think you've both already said a few things about effectiveness of compulsory licensing on their own, particularly in the pharma sector, of course, the question of test data protection and other barriers, basically, to obtain the desired results are often referred to. So what can one do about that? And is that an argument that IP isn't really the problem, but it is other barriers, or is there a combination? And how do we deal with that combination? I think, Bruno, I'll give you the floor first, given that you've mentioned in your study that other things are necessary. So maybe we start talking about what are these? Are these a combination of compulsory licensing with other tools, and how would that work?
The study certainly revealed that, in the medical sector, the life science sector, there is a problem about data exclusivity. But there are many other technologies today where the core issue of the IP lies in the data. In the software sector too, in the energy sector too, the data are more important sometimes than the underlying IP, and there is indeed no legislation to access that. We saw in Spain one attempt, and in France an attempt to include access to data in the legislation, but our searchers did not reveal any commentary or any guidance about how that then should be done. And this calls again for another approach on looking at intellectual property and at data. It is not a matter, I think, of giving the governments and authorities a tool to force the owners to make them available. It's about looking for tools that encourage the owners to make them available via, that's my business, what I'm doing now since I left my practice as a patent litigator, the impact licensing, encouraging IP owners and commercial companies to create societal impact and to show that you create societal impact by making your IP, in the large sense of the word, data also included, available to meet societal needs. And I think that's a new vision, a new approach that the United Nations have adopted since a long time when they issued the SDGs, the Sustainable Development Goals. And the answer is not that the authority should have tools, but that every IP owner should have its part of the social responsibility to make sure that the technology is made available against remuneration, of course. That's part of the whole idea, is that intellectual property can be valorized in a way that everyone is actually winning from it. But the goal is not necessarily to maximize profits or to knock out the competitor, but to make sure that the society is becoming better of it. And that view is prevailing more and more, and calls for other mechanisms that encourage IP owners and societal markets to come together. And it is those tools that I think portions of the Commission's proposals also try to stress. But of course, one looks at the very extreme proposals. But there are other tools also that should be explored. We have the license of right now available in the unitary patent. We'll see if that would work. We see universities adopting policies whereby technology cannot be exclusively licensed if there are certain purposes, certain geographical markets not served by the technology. These are all other tools that are under development and that I think are a welcome alternative to the last resort option, which the compulsory licensing has been designed to and should remain as such.
And if
Go ahead,
I may,
Tom,
Wolf,
yes.
just to that point, because there we have 100% agreement. Bruno, I think what you do with impact licensing is very valuable and very helpful, and that's the way to go. We need to find a way to deal with that in terms of responsibility, voluntary approaches, etc. If then at some point the lawmaker thinks it's still not good enough, based on facts and evidence, so to say, then maybe a regulatory intervention could be an issue. But if you did it, and that's a very bold thought now, then I would do it right, and I would grant compulsory licenses, or however you call it, on a product or use case level, including everything, to be actually able to put a product on the market next day, so to say, or depending on manufacturing, etc., later. So that would be the way to do it right. Question is whether corporate social responsibility, ESG, all these initiatives that we now see will make that unnecessary. It's always easy to say, hey, we should do it and we should be generous, blah, 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 blah. The question then is what actually happens, right, in crisis times. But I don't think we yet have cases, and COVID is just a great example, where this would have been necessary. It worked without any official tool based on law.
Well, I think there are a few countries that would disagree with that assessment that it worked well in COVID around the world. I think one interesting aspect of this is, of course, I mean, in the COVID discussion, particularly in the context of the TRIPS decision and the subsequent discussion about whether to extend it to therapeutics and diagnostics, which is still ongoing. The equivalent of impact licensing in the pharma area is, of course, the medicines patent pool, which is very active and successful in collecting voluntary licenses of pharmaceutical patent holders for large groups of developing countries. But the interesting thing, of course, is that these voluntary licenses include a certain number of geographical areas, but not all of them. And that, of course, is the margin call, so to speak, whether a particular country or territory is still considered to not be sufficiently interesting for the patent holder so that he would give a free license for production or supply in this area, or whether the right holder still believes that this would be something that he would like to supply himself or through his channels. So these territories then, of course, that are some of the middle income countries that are then excluded from the MPP patent tools, ask the question then, what should they do? What should they do to still benefit from this? They may not be in the high income countries where the system is working relatively quickly because industrialization is fast. And manages to supply these products very quickly. They are not in the category of countries where free licenses are available through the medicines patent pool, and hopefully producers will actually produce under them to supply this market. So they are at the brink between those areas. I understand, Bruno, that your proposal is to appeal to the general public interest and responsibility of patent holders to provide that. But I think, as Tilman has pointed out, there's a limit, and then it depends on what happens on the ground.
Yeah, and what happens on the ground is important, of course, because the medicines patent pool, for instance, can only be effective in countries where there is efficient patent protection. And you see that in the developing countries, in those countries where there is no IP protection available, they are especially the largest victim of the situation, because no one will invest in manufacturing capabilities in a country where there is no protection. And impact licensing is precisely the idea of not giving away, not doing charity, not giving products for free because there is a need for products, but to enable the local manufacturing against remuneration. And for that also, we advocate very strongly that IP protection should be much broader, that one should stop to say there are countries that are not interesting from a financial point of view, so we will not protect our technology there. Because by doing that, you make it impossible to attract investors and to enable local manufacturing facilities who, against payment, would exploit the technology. So it is not the right answer to say to avoid compulsory licensing, there should be no IP in the first place. That is actually making the problem even worse. No, you should have protection and then make sure that the licensing happens and on fair terms with a societal view. But the problem is that nowadays, indeed, many IP owners simply do not protect. Hence, those countries are depending on charity, on distribution issues, and they cannot develop themselves the manufacturing capability that they should have, again, against remuneration.
Tilman.
Yeah, this is getting boring because I couldn't agree more. No, I mean, Bruno is absolutely right. The IP is not the problem. And also, Wolf, and you said, well, vaccines, COVID didn't work in some countries. Yes, true. But that was not an IP problem. That was not an access to patents problem. And even in Europe, where Moderna and others are now fighting each other over those vaccine patents, all of them are not requesting injunctive relief. They're just going for the money, which is fair enough because somebody has developed something and then it must be paid. And I agree with Bruno, if there could be an incentive to make patent protection, that means applying for patents and other things, profitable, at least a little bit profitable for companies, so that they would also go to third world countries and other countries and protect themselves there, which again is a long shot because it would require a good judiciary and all these things. But if there was say a smaller monetary incentive, but it would still under the bottom line make commercial sense, then we would be there, and we don't need rules for that. In cases of disputes, courts are good enough, and you have proportionality, you have all sorts of defenses and arguments, which have been thought through for centuries, in fact. So I think the question is how to do it in a way that both sides actually have a win-win. And that must be the objective. And ironically, when you look at the compulsory licensing proposal, the originators obviously hate it, but also the generics. So this is the one legislative proposal which I have seen where actually both camps are unhappy, and that's a bit of a strange result.
I could agree more.
We are. Sorry, go ahead, Bruno. Yes.
No, I agree with Tillman. Indeed, this becomes boring.
Yes, this we are at the worst possible situation where all panelists, speakers agree with each other. So let me then raise one more element that I think we've arrived at, and which is relevant from the TRIPS agreement and the TRIPS decisions point of view. The question of whether it is indeed IP that may make an investment proposition for a developing country interesting or not, and I think you've both agreed that abolishing it is not the problem, or is not the proposition rather. The TRIPS decision, which contains a very targeted waiver element on Article 31F of the TRIPS agreement, which is the provision that is intended to normally limit the export of products that are produced under a compulsory license. And the MC12 TRIPS decision waives that provision for COVID-19 vaccines precisely in order to create, or to, in principle, create a larger market, a possibility of a larger market for a production facility in a developing country to cater not just to its own market, which may be limited and therefore limit the investment proposal, but potentially to other developing countries, thereby creating a larger market. And I think it's fair to say, probably, to characterize this agreement at last June as a compromise, in the sense that a number of countries agreed with, I think, both of you, and thought that IP was not the problem of the supply shortages of COVID-19 vaccines, but they agreed that in order to help diversification of production in the long term, they would be willing to waive Article 31F for a period of 5 years, so that if all other conditions for an investment proposal in a developing country were there, and of course they all emphasized that there were many other factors in this, such as financing and infrastructure and personnel, etc. But if these were all present and it was just the IP limitation that limited the market, that they were prepared to waive that for 4 years, even in a sort of easier fashion, then it can already be waived under 31 bis for the next 5 years. So that is the element of the TRIPS decision that tries to address precisely that aspect of it. So far, we have not received any information from members that is used in practice or applied in any of the developing countries. But the question is now discussed on whether this should be extended to COVID-19 therapeutics and diagnostics. Given that you seem to agree on everything else, are you also agreeing on the prospects of this particular discussion, or is that a top? What are your thoughts on this prospect?
I have no particular views on that, and that is simply based on the finding that when we made the study, there is a European regulation regarding the export of products covered by compulsory licensing, and the purpose of that regulation was to avoid that the member states would individually start to be in competition with each other to be as generous as possible when it comes to export. Which is not possible, and therefore there is a central, I would say, decision mechanism to make sure that this is done with a minimum of policy. But so far as we could find, it has never been applied, and that's why also the few proposals are being made by the Commission to change that regulation. But I have no particular views on whether it is a good thing or not. Again, a country should not be dependent on supply from another country or from another place. They should be able to help themselves. And this is exactly what technology transfer is about, to make sure that you enable countries to help themselves rather than be depending on supply and charity. That is the whole idea about impact licensing, and I stand for that.
Yeah, similar considerations, maybe a bit more nuanced.
Right.
Wolf, you're on mute.
You're still on mute, Wolf.
Sorry, go ahead, Tilman.
Yeah.
Similar considerations, maybe a bit more nuanced. I mean, this topic's not near and dear to my heart, so I haven't even studied it. Why? It doesn't. I don't have any. I haven't seen any case in practice. So why would it be relevant? It could well be a paper tiger. That means something which has been done but will never be used. However, I do think that these type of ideas, so very targeted, very specific to specific scenarios and situations, if they were done on a product or use case level, they make a lot of sense. Because if you have one, so to say, you can copy it for other situations, and you can try to do that, so to say, quickly, or you do it in an abstract form, but you make clear this is last resort, this is the last option. This is when everything else just doesn't work and we have a real crisis with real lives at risk, etc., etc. So such a safety belt, I think, makes a lot of sense. My personal view would be that we have these safety belts in our law already, so we don't need it. But if people are happy to have it, if respective cases come up, fair enough, let's use it. My anticipation is that this is not going to be used in the next 10 years.
20.
I didn't dare 20, Bruno. Thanks for that.
I see. I think it's getting worse and worse. There's so much agreement. I think it's getting complicated. Let's look at the chat and see whether we have any interesting questions. I can see that we have one question from Burkhard. And I'll just read it. I think we've covered some of it. From Burkhard Goebel from Hogan Lovells. And his question is to Bruno: has IP, including patents, not always been out there to serve society? The whole thinking behind establishing the patent system more than 120 years ago was to trigger innovation and make innovation public. That is a public purpose. Could compulsory licensing not work because it is the wrong tool? Too slow, too late to combat crisis.
Yeah, I think that the original idea of compulsory licensing was indeed to also to serve society. The patents are there indeed to teach others to practice technology. Nowadays, unfortunately, patents are only a small part of the technology that is needed to make products and to make certain systems work. So the importance of patents is becoming, I would not say smaller and smaller. I would not overstate the problem. It's still the most efficient tool to enforce a competitive position. But the importance of data is becoming more and more important. And in our impact licensing model, we try to use the data as an encouragement to the IP owner to make his technology available, because if he gives a license on his technology, he gets the exclusive access to the data that are being generated by the use of his technology. So I think the compulsory licensing system should also evolve a little bit if it has to be applied, and try to see how data could be made available or be less protected to a certain extent. And there is, I think, a general public interest that data are not overprotected, but that only the methods to analyze data and the results from those analytics can be protected, but not the data themselves. But that's another another discussion. But to answer the question of Burkhard, I think indeed it is not the right tool. It has to evolve. It has to be improved. And yeah, we are no longer living in the world of 150 years ago when the patent system was first designed.
Yeah, I think probably I understand his question as saying that that it is the patent system that provides the access much more quickly than the compulsory licensing. I don't know whether I'm misreading Burkhard's question, but I think that's the argument that many would make, and which has certainly been raised in the TRIPS discussions, saying that the market forces and the collaborations of the right holders to produce and to manufacture crisis-relevant products is the most efficient and the fastest way to getting those things to the market. That's certainly what many have argued, and compulsory licensing is just more complicated and therefore less efficient. I think that was that's how I'm reading this. Sorry, Burkhard, if I'm misquoting you. Tilman, sorry, did you have a comment?
No, I think we're running over anyway, and it's dinner time, at least in Germany, so roughly. No comment.
No comment. Okay, we have one more comment very quickly from Octavio in the chat, who points out that the issue with access to pharma products is not necessarily trying to establish local production, but allowing importation from foreign providers. Manufacture can be done cheaply in India or China. However, can the products then be exported and imported into Mozambique or Bolivia? This is the stage that seems to be critical. 31 bis is not feasible in its present form. Any famous quick last thoughts on this one? I mean, I agree to some extent, and I would point to you, Bruno, when you said the idea is, for countries to help themselves. That's fair enough. But I mean, will there not always be products also for developed countries that they cannot produce themselves, and that, by the market forces, manufacture has become concentrated in a certain region, and therefore we are all the ambition is not to everybody produce for themselves, but to keep the trade routes open to have these products produced efficiently elsewhere and then imported.
Yeah, the market should play. I mean, there is a question of demand and offer. However, in times of crises, things change, because then you need local manufacturing, local access. As the COVID crisis showed, transportation routes were blocked. There may be a need at some point in natural disasters where local production is urgently needed. And I can understand that governments want to be prepared for such a situation and want to have legislation that covers that hypothesis, and let's hope it doesn't happen. But we are living crisis after crisis in food, in energy, in everything we have. So we better be prepared.
Tilman, you have the last word before we hand it back to the organizers.
Thank you very much for a great discussion.
Well, thank you both. We are over time. I'm handing back to the organizers. We could probably go on, and we've arrived at the point that where the TRIPS Council would take on the discussion in our next meeting. So thank you all. Thank you both. for your contributions, and thank you for the organizers for putting us on. Thank you very much.
Yeah.
Thank
Thanks,
you.
Thanks very much. Well, having had you as a moderator of this 31st encounter has been a pleasure and an honor. So they are Tilma, they are Bruno. We are also very grateful to you. Please be welcome to you three. Be welcome to the Encounters family. You know, the Encounters family is a family already composed by 100 of remarkable scholars and professionals, and this is our great honor. Again, we have dealt with quite an exciting topic. You have highlighted properly that testing the borders of IP means necessary to balance the IP system in our present times. I think it was Bruno who said our present times of severe crisis, yeah? And certainly compulsory licenses are without any doubt a very key tool at a world level, yeah? Including the long-standing discussion you have dealt with on whether matters should be brought to the attention of the European legislation or rather left to the expertise of national judges, if I recall well, Tilman, including the UPC judges, yeah? Or I recall the question whether the whole issue is just IP or rather there are many other issues you have brought also on the table, access to data, access to technology, and so on and so forth, yeah? So no doubt this is one of the most complex issues we have brought on the table. Yeah, even if you appear to have agreed with each other in the numerous of the items discussed, and we try to push here people just fighting to each other more than agreeing to each other, but there was no way that agreeing. Yeah. I have the feeling anyway that we could have spent many hours reflecting on the role of compulsory licenses, but believe me, you will be surprised when recognizing the number of questions you have brought on the table just in 1 hour. Yeah. By the way, something I would like to announce to you is that from this encounter, we will also provide to our audience with some of the key assessments you have brought to us this afternoon, yeah, as a kind of small pills, yeah. So I would like also, because this is a must, to recall that this time the report will be drafted by Ruben Cano and by Julia Borisov. Yeah. So thanks to you, Ruben and Julia. I would like to emphasize again and again that the encounter reports has become a precious instrument for researchers and for professionals. You know, the encounter support team has already provided to you 30 splendid reports, and we see that these reports are consulted every day dozens of times. Yeah. By the way, it is also a great pleasure for me to announce you that two of the members of our support team, so mainly Letizia Tomada and Vicente Zafria, very successfully defended the doctoral Marie Curie thesis last week, at the same time at the University of Augsburg and at the University of Alicante. So congratulations to both of you, my dear doctors. Yeah. Many thanks also to those who have attended the encounter today. We are very grateful to your fidelity as always, and thanks also to the hundreds of non-attendants but readers and people who will listen the recorded copy of the encounter in the next weeks or in the next months. Yeah. So take care. Join us again for the next encounter. The next encounter will be the 32nd. This will take place on 18th of January 2023, and we will come with quite an exciting topic also, mainly the evaluation of 6 months of life of the Unified Patent Court. Yeah, quite an issue. So as always, we will prepare materials for you, we will prepare references for you, and we will provide splendid speakers for you. Thanks for being with us. Enjoy the rest of the day, and please do not forget that Christmas are coming. And greeting to all of you, and greetings to your family. Bye-bye. Thank you.
Thank you, Manuel. Thank you, everyone.
Thank you.